Our first speaker today on this program is Mr. Bruce MacDougall, who will speak on the fundamental principles of insurance law, subrogation, insurable interest. I've asked Bruce, who has a very, very strong background in this area, to highlight for you the basic principles, and from there on we'll proceed with the balance of the program this morning. There will be an opportunity for questions at the end of every presentation, and I would ask you to save your questions until the end of each speaker, please. Mr. MacDougall.
Thank you, Barry. I must say that I'd like to start out this effort by directing your attention to page 10 of the notes of my lecture, and the reference in particular to the Johnson and Eaton's case, which has an error in it. I think it's at about line 8, where the date is shown 17 September 1977. That should be, 17th of September 79. That should be 17th of September 1977, and it should be followed by the words, and would have vested absolutely on 17th September 79. And then the following words, unfortunately, she died 6 days later on 11th September 79. 6 days earlier on 11th September 79. I know this may sound somewhat odd coming at this stage, but I thought that at least you would see that it's a demonstration of the fallibility of your lecturer, and also the fallibility of Mrs. Johnson herself. And I'd like to hope will illustrate the importance of living more than 2 years after insuring your life. At this point, I'd like to go on with the main part of the lecture. The subject, of course, of general principles, recent developments in general principles, is much like wrestling an octopus. Almost all insurance cases are applications of basic principles, and therefore it would be possible to refer to all of the recent decisions in doing this paper. I've elected instead to restrict my remarks to the areas that are currently in the eye of the legal public, and I'll attempt to give some insight into how those current developments may affect the practitioner. Before dealing with the specifics, I'd like to make some general observations regarding the practice in the insurance area, which you may hear from time to time in some respects throughout the day. But I'd like to offer some of my comments. Firstly, I'd like to say that insurers generally have very strong views as to what they believe a policy was intended to cover. This leads them, in some circumstances, to agree that there is coverage, where the actual wording may be somewhat iffy. But on the other hand, where they believe there is not coverage, they can hang very tough indeed. A second general point, insurers are generally interested in paying claims. They're not interested in litigating unless it's a last resort. If a coverage argument can be made, therefore, regardless of whether you're on the plaintiff's side or on the defense of the insurance company, you would be well advised to look at that argument and make sure that you and the insurers understand it at a very early stage. Third point, many insurers have a very strong sense of morality. Suspicious circumstances, even if no misconduct can actually be proved, makes them very tough to deal with. And in fact, it can characterize the case right to its conclusion. Analysis of the decided cases will show that many of the cases which we all regard as bad law have their origins in suspicious circumstances. And finally, in a general way, a word about reserves. If acting for an insurer, always remember that they want to know the whole truth as soon as possible. This means a realistic assessment of the case, not only from the damages point of view, but also also in respect of all available defenses, factual and legal. If you're acting on the other side, you have to try and make your case as soon as possible, whether it be at a meeting with the insurers, a meeting with the adjusters, a meeting with the lawyer on the other side, correspondence, pleadings, any way that you can, make your case so that the insurers and their representatives understand the strength of your position. The higher the reserve is, then the more likely that your client will get a favorable result. All right, on to particulars. The first subject I'd like to deal with is insurable interest. In insurable interest, the case of Cosmopolis and the Constitution Insurance Company is big news. This case, coming out of the Ontario Court, the Trial Division, Dick Holland, going to the Court of Appeal, is now on appeal to the Supreme Court of Canada and likely to be heard this fall. The facts in Cosmopolis are fairly straightforward. Mr. Cosmopolis was a Greek immigrant who started a leather business in Toronto, and he started it in the usual way, an unincorporated business. He placed insurance, he owned the business, he owned the premises that, he leased the premises in which the business was in, and the business was operated in just a trade name. He placed insurance on the assets of the business, and then 2 years later, incorporated the business. He understood little English and was not really familiar with the general consequences of incorporation. He had an insurance broker, and the insurance broker, although he placed the initial business properly in the name of the unincorporated name, did not twig to the change to the corporation, and so in 1974, when he renewed the insurance, there was no change in the insurance policy to reflect the corporation. So what we had at that point was Mr. Cosmopolis, who was a sole shareholder in this corporation, being the named insured in a policy of fire insurance with other perils, which in essence insured the assets of the corporation. I might add that although it doesn't appear anywhere in the reasons for the decision, there were at least on the part of the insurance company was a suspicion of some odd circumstances surrounding the fire, which occurred later and destroyed the assets of the corporation. The case is interesting because it demonstrates several points which are very important in connection with insurable interest. Firstly, I should point out that the Trial Division was able to distinguish the prior law in the case and held that Mr. Cosmopolis should be able to recover on the basis that this was a sole shareholder and not another shareholder of a corporation which in the past had been held not being able to recover when damage was done to a corporation's assets. This decision was affirmed on appeal with additional reasons by the court, and as I said before, the case is now on its way to the Supreme Court of Canada. The logic of this decision is flawed. What is going on here is that the court is having to deal with the problem of piercing the corporate veil in reverse. So what is happening is that even if it's a sole shareholder, is placing insurance on the assets of the corporation, in theory, if he is able to recover all of the assets of the corporation, then those assets, in theory, could go into his pocket and the creditors of the corporation could be defeated. Now, there may be ways around this. The Supreme Court of Canada may find some way to pierce the corporate veil in return by perhaps creating a constructive trust. It could, on the other hand, allow the shareholder only to recover his actual loss vis-a-vis his interest as a shareholder. What the Supreme Court of Canada will do is yet to be seen. Going back to the previous decisions, it's of some interest to see how we got there. All the cases in this area can be traced to two of the court's reasons, of the reasons of the House of Lords, in a case called Lothian and Crawford. In one of the cases, Mr. Justice Lawrence stated the test for insurable interest to be moral certainty of loss. On the other hand, Lord Eldon stated the test to be a legally recognized right arising out of a property or contract. You can see that there can be many circumstances in which the interest that you might hold might very well be morally certain of loss in the event of some damage or loss of the asset. But in quite a lot of those cases, you may not have a legally recognized right. So that there was a complete divergence of cases going one way and the other. In both of the United Kingdom and Canada, although the decision of Lawrence, which reads beautifully, has been quoted many times, it has never been followed. On the other hand, Lord Eldon's decision, which is quite restricted and not so attractive, has been followed every time. In the United States, the situation is exactly the opposite. The problems trace themselves further than to the House of Lords in a case called McGrenere, where there was as in many of these cases, a strong odor of arson. This case was applied in Canada in a case called Aqualand, where a corporate asset, being a drilling rig, was destroyed or lost in a storm on Lake Erie. There was certainly no strong odor in that case, and in fact, in Brown and Menezes, the authors have stated, quote, no inexpensive technology exists for creating such disasters in order to permit an insured to benefit from insurance policies. So that what we see is that a combination of a hard case and unproven immoral plaintiff can make bad law. The second point that it illustrates is that the development of insurable interest from the insurable interest law from what at one time was designed to prevent gambling by way of insurance to the present status. Many years ago, back in the 18th century, it was common for members of the general public, or rather members of the business community, to gamble through insurance. What they would do is, in essence, make a bet on the possibility that some ship would be lost going around the Cape of Good Hope. Whether this is really any different than Wintario is still to be seen. This gambling, which fell into moral disrepute, if you will, was ended by both statute in some areas and by the common law. The purpose, apart from the putting an end to gambling, which was regarded as immoral, was also to reduce the moral hazard. It's true that it's very difficult to affect the safety of a ship going around the Cape of Good Hope, but it's not anywhere near the same to consider the same issues in relation to arson or other things closer to hand. so that there was a real intent to try and stop the moral hazard. Now we see with social change that gambling is a relatively moral sport, and so far as the moral hazard is concerned, we have other laws to take care of it, and possibly the principle of indemnity could also apply. Fire and most other insurances is subject to this principle of indemnity. That is, the insured should not be allowed to profit from insurance. In Cosmopolis, this particular issue doesn't apply because in Cosmopolis, although I mentioned before, it would be possible for a shareholder to take out an insurance on all of the assets of the corporation, ignore the corporation's debt, put the money in his pocket and walk away. In Cosmopolis, it doesn't happen because Cosmopolis was also the guarantor of the corporate debt. In any event, in Cosmopolis, the Supreme Court of Canada will decide. What we will see in all likelihood is that it will provide the direction for the subject of insurable interest in days to come. There are some other recent cases in Canada which deal with insurable interest. Many are just as colorful as Cosmopolis, but none are as important. Two of these recent cases involve imported goods, and I think they serve to demonstrate the manner in which the courts manipulate the doctrine to bring about what they see as a proper moral conclusion. In the one case, the plaintiff was the nephew of the man who originally brought the goods in, and he said by way of his case that he had nothing to do with these goods. They happened to be a fur coat brought from Italy, and his uncle just brought them in and gave them to him. And sure, his uncle hadn't declared them and hadn't paid the requisite tax on them. But on the other hand, he had nothing to do with that. Well, when they went into it, they found that there was some sort of discussion between the plaintiff and his uncle, and there was a strong suspicion that the arrangement had been set up for the uncle to bring the goods in and hand them to the plaintiff. The reason that the plaintiff in that case, even though he had possession of the fur coat and could hold it up to be photographed, the reason he had no insurable interest was that in the Customs and Excise Act, if goods come into the country, they're not subject to being seized, but they are forfeited without any steps having to be taken. In the other case, on the other hand, the plaintiff brought some jewelry in, and the plaintiff had been given some jewelry which had been brought in much the same circumstances as the fur coat from Italy. But in that circumstance, the judge believed the evidence that the goods had been verbally declared to the customs officers coming through, and therefore all the plaintiff really had to do was to make a written declaration following up on that verbal declaration. It may be a factor in that case that the plaintiff, in addition to having a moral position which was sustainable, also wouldn't have had to pay any duty on the goods. There are some other cases of interest as well. There's a case of an innocent purchaser of a stolen car who was held disentitled to recover by reason of not having insurable interest, and some other cases in similar light. The cases show little consistency. Many have been colored by the conduct of the insured, and as I mentioned in my opening remarks, these are the kinds of cases that the insurers will tend to fight. On subrogation. Subrogation is a concept, a principle, which has been with us more or less forever. Only recently, that is in about the 17th or 18th century, did we see it applied in the concept of insurance. it's of some interest to note the background to the basic case in subrogation, Castellane and Preston, because Castellane and Preston had been preceded by the case of Rayner and Preston, which deals with facts which are near and dear to the hearts of many of us. In Rayner and Preston, Rayner had agreed to sell some property, some real estate, to Preston, and so that during the period that the contract for the sale of the property was in effect, but before the possession had been handed over before the closing, the building on the property burned. An insurance had been placed by the vendor, by Rayner, and the first case was Preston seeking to recover from the insurers the insurance monies in which Rayner, the vendor, was named as the named insured. Coincidentally, of course, Preston at that time was still contractually obliged to pay for the property. Well, not surprisingly, I suppose, for the strict constructionists at the time, the court held that Rayner was entitled to the insurance monies, and Preston had to pay for the property as well. Well, it's not surprising then we move on to Castellane and Preston, where the insurers became subrogated to the rights of the vendor to pursue whatever rights those were, which in the circumstances was the collection of the purchase price from Preston. And the quote which you find in the materials is the basic statement of subrogation. What you find there is that the court held that the insurers were entitled to step into the shoes of Rayner, the vendor, and to recover from the purchaser, Preston. Well, one of the things, apart from the general statement of the principle of subrogation as applied to insurance, one of the things we have learned is that in contracts for the purchase and sale of land and the contracts of many other kinds, it is essential to cover the issue of where the risk should lie and place insurance to cover that risk. Now, although this doctrine has been with us for what amounts to centuries, in recent years we have seen considerable whittling away of the doctrine. This has been the result of increasing legal expenses, the impatience of the courts, statutes, no-fault insurance, etc. But in particular, there are recent developments which may be of interest to the practitioner, which are basically concentrated in two areas. Firstly, are contracts on the part of A to insure the interests of B, who is a tortfeasor. This is often seen in the case of landlord and tenant, where a tenant's negligence may start a fire and burn the premises down. And what we see is the courts doing an analysis of the circumstances to determine whether the intention in placing the coverage was the intention in the contract itself was to put A in the position of being obliged to insure not just his own interest, but also the interest of the tortfeasor, that is B. An example of this type of case was Eaton and Smith, referred to in the notes, and you can see the type of analysis the court went through. The second type of case is the situation in which an insurance has been placed by A when he had no obligation to do so, but extends, or at least so the courts find, extends to cover the interests of the tortfeasor B. An example of this latter type of case is the Commonwealth Insurance and Imperial Oil case, also referred to in the notes, what we see there is that the insurance company, in placing a contract which covered, they're placing an insurance which covered a large construction endeavor, included by referring to subcontractors, all subcontractors, one of which happened to be the Commonwealth, whatever it is. Insurance was placed by Imperial Oil, I believe. Now, you might ask how this has to do with subrogation. Well, going back to what we were saying before, the principle of subrogation involves the insurer stepping into the shoes of the named insured and looking to the tortfeasor. Well, if the tortfeasor can't be sued because the named insured has already agreed to insure his interest, well, then there's no subrogation. Likewise, in the Imperial Oil case, the same principle applies, only at one step further removed. There is another case of interest in this area, which I won't deal with at length, and we have not seen actually in this country, but has been the law in the United States for some time, and that is a placement of situation where there's an insurance placed by A to cover the interests of the tortfeasor B, but not as a tortfeasor. In those circumstances, particular circumstances of a leading case, B was a manufacturer of components and negligently manufactured, or allegedly negligently manufactured the components, but he was also a conditional vendor, and so had an interest as a conditional vendor, which A had agreed to insure. And the courts have held that A can't recover against B, or excuse me, the insurers of A can't recover against B in those circumstances because the insurance was intended to cover the interest of B, even if not in the same capacity as placed. It's sufficient to know in the area of subrogation that the interests are being, the principle is being whittled away at. The courts are not favorably inclined to subrogation cases, and if you have a case in this area, whether you're on the plaintiff's side or the defense side, you have to look very closely at the case to make sure that it hangs together on the one side, or before you recommend on the defense side that your client pay, make sure that there is a good case against you. On the issue of double insurance, which is the next area, I mention this area only because of the increasing frequency of double insurance in our society. It's also important to lawyers because discovery of other policies becomes a real detective game. I have included in the notes a couple of examples of double insurance and have set out the basic conditions for determining whether double insurance exists. If I can just briefly illustrate the issue, though, with a brief story myself, we had a case several years ago when we were acting for an airline. The airline had some goods stolen by its own employees. These were goods which were being carried as cargo. The airline had two insurances which could conceivably cover this. One was liability insurance, and the second was fidelity insurance. There were different insurers involved, and clearly in the circumstances there was a right to claim under both policies. This is not double insurance. If there had been no claim under the fidelity policy, then the loss would fall under the legal liability policy. There was no obligation to claim under the fidelity policy. If, on the other hand, there had been a claim under the fidelity policy, the goods or the equivalent of the goods would have been replaced, and although there may have been some delay giving rise to a claim, that would be the only claim under the legal liability policy. My time is getting on here, so I'll flip right over to the last subject, back to contra preferentum, and back to Mrs. Johnson. Mrs. Johnson's case is just an example of the application of the plain meaning rule in the construction of insurance policies. The Court of Appeal at least found that the words in that case were clear and unambiguous, and therefore the principle didn't apply to assist the insured. This case, which on reviewing it you will see, involved the issue of what was meant by the words "no illness" since taking out her first policy. The trial judge found that the word should mean no new illness, or he imported that word "new" into the words of the answer to the question, and held that she didn't have to disclose her pre-existing high blood pressure. And the Court of Appeal disagreed. They said the words are clear and unambiguous. On the other side of the ledger, and as an example of the American approach to the subject, you see the case of the Holiday Inn in Beirut, which is referred to in the notes. In that case, the Holiday Inn was destroyed by mortar shells in a conflict which took place a few years ago. There was a fire and extended perils cover, as there might well have been. I think it was described as all risk cover. But it was subject to an exclusion for war. But brilliantly, the U.S. court found that there was a distinction between war in the common or well-known sense and war in the insurance sense, and this was not war in the insurance sense. Well, we have few Beirut Holiday Inn cases in Canada, but the judicial tendency is there to try and find the coverage for the insured if possible. There is one change on the horizon which is worth looking at. If you're dealing with mass-produced policies and basically consumer insurance law, you're not going to see this kind of thing. But what is happening more and more is in any kind of corporate environment, there is a negotiation process which leads to the finalization of a form of insurance policy. And there is some movement toward looking at this kind of situation where there are relative equals negotiating the contract as involving different principles of construction than the strict construction or contra preferentum rule, which is intended to apply only in circumstances where the insurer has all the knowledge, has all the forms, and it should be construed against them. I think that brings me to the end of my talk. I think that I have referred in general at the very end of my paper to a short summary, which I commend to you. Apart from that, I'd just like to refer and go back to the insurable interest point and refer to one quotation of the Master of the Rolls in a case called Stock and Inglis in 1884, which highlights the attitude of the courts to this issue. In that case, the Master of the Rolls said, quote, "It is the duty of a court always to lean in favor of an insurable interest, if possible, for it seems to me that after underwriters have received the premium, the objection that there was no insurable interest is often, as nearly as possible, a technical objection and one which has no real merit," close quotes. So that, as you can see, all of these cases are cases in which the insurers have actually received the premium. And I think in those circumstances, if you are in those circumstances, you should have considerable effect in your argument that the coverage should apply. All right? Oh yes, questions. Barry has mentioned that there should be a period of maybe 5 to 10 minutes questions. If you could try and give me your question as clearly as possible, I will have to repeat it in order that the television monitors can pick it up. Questions? Yes.
What is the present practice in obtaining the Tortfeasors insurance policies? Copies of them?
What is the present practice in obtaining the Tortfeasors insurance policies?
Can you receive copies of them?
You are speaking of a situation in which you are making a claim against somebody who is a tortfeasor. In my experience, unless there is an issue of coverage which relates to the claim itself, the policy would not ordinarily be produced. The issue may very well be made in the case that the plaintiff is entitled to the benefit of some clause in the tortfeasor's policy. Now, if that is the case, or if there is a reasonable belief that that is the case, and you can make that out, then you should get your order for a further and better affidavit on production, which should include that policy. Mark, are you going to say something on this?
Sure, go ahead, Mark.
I don't mean to jump into what you're talking about, Bruce, but that very problem has come up in the SCF 42 coverage, where the policy is directly an issue that the courts have held. Mr. Justice Carruthers in the Peters case has held that under Rule 349 you cannot get production of that policy even where it is the guts of the lawsuit. So the short answer is no.
Mark, I should just add that Mr. Justice Montgomery this afternoon will deal with certain new rules. When the new rules come out, there's some provision made in the new rules which I think will overcome that obstacle.
We could get those new rules in place by about 2 o'clock this afternoon.
No, they're going to be in place in January, so I think we should look forward to what Mr. Justice Montgomery has to say on that topic. You'll find it interesting, I know.
Any further questions?
I think we've got to move on. I just have one comment to make. I think we should all read the Beirut Holiday Inn case as to refine our talents for distinction. I think we should also read it because, in particularly in insurance law, the Ontario courts and Canadian courts will look to American decisions and jurisprudence and apply them, not as binding, of course, but find them very persuasive. Thank you, Bruce, for your highlight.